class. Let us pause a moment of silence and place ourselves in the presence of the Lord. In the name of the Father, Son, and Holy Spirit. Amen. All right, good afternoon to everyone. I just learned that there are more than 1,000 of reviewees in this school. I won't be surprised if there will be about 7,000 examinees this coming September. There are more and more aspirants to become lawyers. Well, we can easily discern what is the reason. You know what's the reason? Why so many want to be a lawyer? I will tell you. There is one a parent, a father, who at the age of whose son is still 5 years old. And at that early age, the father already wanted to know what would be the profession of his son. 5-year-old boy. So what he did one evening is to place a set of books on the top of the bed, thinking that if this boy will take these books the following day, then the boy will become a teacher or a professor. On his left side, he placed bills of money on the assumption that if these bills of money will be taken by the boy, then he will be a banker or at least a businessman. And on the right side, he put some fruits, thinking that if his son will take these fruits the following day, then his son will become an agriculturist. So all these things set, he went to sleep. And as early as 5 o'clock in the morning, the father already peeped inside the room. He opened the door and saw his son already awake. His son was eating the apple, all the bills of money inside his pocket, and he was reading the book. And he said, "Oh my God, my son is a lawyer." That is how, or that is the reason why many would like to become a lawyer. You have a buffet of opportunities. Of course, you know what is a buffet of opportunities. There is a simple note here which states, "Can you verify your statement last night that there can be a direct assault in an agent? ? Is there a new jurisprudence to this?" There can be a direct assault in an agent. Maybe this query involves indirect assault. Indirect assault, where I mentioned that for purposes of violation of Article 49, indirect assault, where direct assault is necessary as a predicate crime. Okay. Such predicate crime of direct assault no longer involve a person in authority. I said last night that in this kind of indirect assault, in this crime of indirect assault, the victim must be an agent of a person in authority. All right. If the victim of the direct assault is a person in authority, it cannot be direct. It cannot be indirect assault. Why? Because the person who comes to the aid of a person in authority himself becomes an agent of a person in authority. So that dependent upon the force or intimidation committed against this person who comes to the aid of the person in authority will either be a crime of direct assault or resistance. All right. On the other hand, if the victim of direct assault is an agent of a person in authority, the person who comes to his aid and likewise assaulted is now the crime of indirect assault. Indirect assault. Such person who comes to the aid of an agent of a person in authority does not become an agent of a person in authority himself. This is founded, or the authority here class is the amendment done under 152, because the last paragraph of 152 provides that any person who comes to the aid of a person in authority becomes an agent of a person in authority. Okay? So, this must be the question or the query referred to in this letter, on this message. Okay. Last night, we were talking about this entrapment, and as distinguished from instigation. And I have related this matter of entrapment with the chain of custody. Actually, the chain of custody does not apply only when there is an entrapment. It applies in all cases where there is a violation of 9165. And the particular section of the law is Section 21. Section 21 in relation to the chain of custody. As you will note under Section 21 class, whenever a drug is seized from a certain offender, the same must be inventoried and photographed. And the inventory and photography must be done in the presence of representative from the media, from the DOJ, as well as an elective public official. And as I have said yesterday, this will not render the shabu or the drug inadmissible. It is still admissible, but the credibility of the drug will be put in issue, So that failure on the part of the police officers to explain why they failed to comply with Section 21 might cause the acquittal of the accused. Of course, you are aware that there is the implementing provision. And this implementing provision is where you can find this provision that the same must be explained if ever there is a failure to comply with Section 21. Now, the PDEA agents are the lead agency in the matter of implementation of 9165 implementors. But nonetheless, class, our police officers and other law enforcers can still operate to enforce the law on drugs, subject only to the coordination and cooperation with the PDEA. the PDEA did not exclude your police officers from implementing or enforcing 9165. What are the drugs which are made punishable under 9165? Note, class, that there is no definition what is this prohibited or what is this dangerous drugs under 9165. They are merely enumerated such that you apply your expressio unius est exclusio ulterius. Matters which are not included are deemed excluded. That is why those drugs which are used for cough or cough drugs, cough syrups, which induce a person to sleep or sometimes to make a trip, nagtitrip pa sila, are not included yet. But they are not included yet. Hence, they are not yet considered as dangerous drugs. But if later they will be included, then there is no prohibition for such inclusion as dangerous drugs later on. All right? What are the crimes that are committed? Let's take the more common crimes. Of course, selling. The accused was caught selling shabu and at the same time selling marijuana. How many charges should be filed? There should be 2 charges that should be filed against him. Why? Because the penalty for shabu and this marijuana are different. Okay. Supposing the accused was caught selling and at the same time possessing also other quantities of marijuana, again, there will be 2 charges: selling for the subject of the sale and possession as to the quantity found in his pocket. 2 separate offenses. All right. Possession class will absorb the use, unlike before 9165, possession does not absorb the use of drug. Now, at present, the use of drug is absorbed by possession. In like manner, class, if there are several kinds of drugs, like marijuana, and then you have shabu, and then you have cocaine, there will be 3 different charges. Why? Because, again, there is a different penalty dependent upon the quantity of shabu, quantity of cocaine, quantity of marijuana, yes, dependent upon the quantity, there is a separate or different penalty. Take note of this constructive possession as distinguished from actual possession. When do we say that a person is in constructive possession? It is necessary that one has a control over the place where this drug was found. Because if a person does not have a control over the place where the drugs were found, then the accused may not be held liable constructively. In one case, class, the accused was a guest in the house of his friend. And somebody made a search warrant was served in that house of his friend, and he was found inside the room where shabu were found. All right. The Supreme Court said he is merely a guest, a temporary resident or temporary occupant of the house, and he has no control over the place. Hence, there is a doubt whether or not he could be held liable for possession constructively. In another case, it was the wife who was held liable. Why? Because he was the drugs were found inside the conjugal room, under the conjugal bed. While the woman invoked or argued that I am not in possession because I do not know that these shabu or drugs are kept under the bed. But the Supreme Court said, no, you are constructively possessing because you are an occupant of the house, you sleep in the same bed, you clean the house of this particular room, and therefore you have control over the place. You are constructively possessing the drugs. There was a conviction. Okay? Constructive and that of actual possession of drug. Next point. As regards selling, in one case class, have you seen people dealing with drugs? Of course, many of you, or I would say all of you already have seen the movie involving the dealings of drugs. What do? Of course, they will first show the drugs, and then the offerer or the buyer will also show his money. You show me yours, and I will show you mine. Diba? So, and then from that point, if they find that there is a deal, then they make an exchange. Thus, there is a consummation of the sale. Consummation of the sale. So that in one case class, while they were still doing this act of showing mine, I will show you yours, show me yours, immediately the police officers apprehended these buyers and sellers. Okay? They apprehended. All right. It was too soon. It was too early. Maybe the signal was too soon that the police officer immediately apprehended them. All right. Of course, class, the buyer here was a poseur buyer. Right. Now, one of the argument of the accused here is that there was no sale. The accused said there was no sale because in the first place, there was no payment yet. All right. As to the payment, the Supreme Court said, it is not necessary for purposes of the consummation of a sale. It is enough that there is a delivery. It is enough that the accused received the money and there was an exchange. The corpus delicti of the crime is proven, even if the payment is made after, before, or during the crime is consummated sale. But here, said the Supreme Court, there was no consummated sale because they were yet in the act of making a negotiation, in which case they are not liable for a consummated sale. But then, said the Supreme Court, while they were not liable for a consummated sale, they are liable for an attempted sale. And the irony of it is that whether it is attempted or whether it is a consummated sale class, the penalty is the same. There is no difference. Attempt or even mere agreement, when there is a conspiracy class, it is already punishable under 9165. Agreement to buy and sale is already punishable. Okay? Class, it is good that the framers or the legislators had defined and specifically imposed a penalty for an attempted sale. If I am not mistaken, that is section 26. I am not sure if it's 26. I am not sure. It is fortunate that they have included a definition and a penalty for attempted sale. Otherwise, there would have been no crime. Why? Because attempted presupposes a 2 degrees penalty, 2 degrees lower than that of a consummated sale. And there is, you know what is the penalty for sale? Life imprisonment to death. And there is now 2 degrees lower from life imprisonment. Is there any? There is none. So it is proper, it is perfectly proper that they had defined what is an attempted violation of 9165. In the same manner, class, if you will notice, there could be no accessory or accomplices for violation of 9165. Because the penalty of 12 years and 1 day up to 20 years, the penalty of life imprisonment is likewise cannot be lowered by 1 or 2 degrees. 1 or 2 degrees. So, what then is the liability of a policeman who allowed a violator of 9165 to escape, or for that matter, abuse his authority in order that the offender could escape from his liability? Again, in like manner, class, the law defines what is a protector or a cuddler, so that such protector or a cuddler will take the liability of an accessory under paragraph 3 who harbors or help an offender to escape. And this is a violation where the accused is made or defined as a protector or a cuddler. Protector or a cuddler. Mere failure to account the drugs confiscated or seized is already a crime. So a police officer who failed to account or accounted a lesser amount is liable under 9165 without prejudice to his liability under the revised penal code. Meaning that in addition to his liability for failure to account, he may also be held liable for malversation. Why malversation? Because when a police officer sees a certain property subject of the crime in the course of the apprehension of the suspect, the police officer become accountable of this property subject of the crime, and any appropriation of this article would constitute a crime of malversation. Without prejudice also if there is a falsification in the preparation of the report or apprehension report done by the police officer. Again, I mentioned to you that professors and teachers are deemed public person in authority under Section 44. Under Section 44, they are deemed person in authority. Plea bargaining is no longer allowed under 9165, although probation may still be applied. But if you will notice, it is quite impossible or nay impossible that probation will be applied, because most of the penalties are more than 6 years. And in fact, there is a provision under 9165 that probation shall not be applied to drug traffickers. Of course, we may want to imagine how would this probation apply under 9165 when the penalties are more than 6 years. Class, this would practically pertain to a minor, since a minor who commits a violation under 9165 may be placed on probation, despite the penalty which is above 6 years. subject only to the provision that he cannot avail if his crime involves drug trafficking. Drug trafficking. He cannot avail of this. I think Section 26 involved aggravating circumstance. Correct? Aggravating circumstance where a person who in the commission of a crime is under the influence of drug, in which case it is considered as a qualifying aggravating circumstance, quote, unquote. Why did I say quote and unquote? Because there is no jurisprudence yet interpreting the meaning of this qualifying aggravating circumstance, so that if it is committed by, if it is applied to a person who killed another person under the circumstances of homicide, will now become a crime of murder. Will now become a crime of murder. All right. But your answer should be, it is deemed or considered as a qualifying aggravating circumstance. No more, no less. And perhaps you may say, since it is a qualifying aggravating circumstance, then it may qualify the killing into a crime of murder, because that is the necessary effect of a qualifying aggravating circumstance. But personally, this should have been only a special aggravating circumstance. Special in the sense that it is provided that the special law, and secondly, it cannot be offset by a mitigating circumstance. And that peculiarity makes it special. All right? Peculiarity of not to be offsetted by a mitigating circumstance. Okay? So, no plea bargaining, probation may still be applied. And then I think this one may be asked regarding this mandatory drug testing. Unfortunately, class, this mandatory drug testing was questioned by your legislators. And in fact, they were the very first one who questioned it. The national elective public officials. In that case of La Serna, SJS, etc., they questioned this validity or constitutionality of this drug test. As you would know, random testing is required in schools, students. Random testing also to employees, random testing. And then random testing also on public officers, national, elective public officers, national or local. National or local. And then drug testing also to suspects or offenders who have committed a crime above 6 years penalty, above 6 years penalty. All right. This matter of drug testing was questioned before the Supreme Court recently. And of course, you know what was the ruling of the Supreme Court. That is why your congressman there in Hong Kong now was caught. If there was then a drug testing, I don't know if that violation could have been averted. But that does not matter anymore. All right. You know that the Supreme Court declared invalid the drug testing insofar as national elective office, public officer is involved. National. Why? Because the qualification of national elective public officials are determined in the Constitution. So that the drug testing provided in 36G of your 9165 would amend the constitutional qualification of a national public official. And this cannot be done by a mere statute. A provision, of course, under the Constitution shall only be amended by the Constitution itself or by the process of constitutional amendment. Okay? All right. As regards the drug testing of suspects, again, the Supreme Court rendered it invalid also. Why? Why invalid? Because according to the Supreme Court, it is against the privacy of a private person, as well as it is incriminating. You will be incriminating the suspect if he will be subjected to a mandatory drug testing. Take note, mandatory drug testing. Hence, it was also rendered invalid. But the Supreme Court sustained the drug testing as regards the students and employees. The employers has the right to ensure the working conditions of the company or their business so that they may conduct a random drug testing. In like manner, students in the schools are acting as locus parentis, and as such, they are bound to ensure also this drug-free school, as well as to prevent this prevalence of drugs. Okay? And besides, said the Supreme Court, if you enroll in a certain institution, you are bound to abide by the rules and regulations of the school. You are bound to abide by the rules. And of course, this is a random testing, and it is not directed to a particular individual. Not directed against a particular individual. All right. I think we have more than enough about 9165. 9165. Section 21 has been very, very familiar to everyone. I don't think Section 21 will be asked again in the bar exam. But we do not know. It may be a variation of this problem, but a variation of a problem of the problem given last year. Title 6. Title 6 are crimes against public morals. There is not much in this title. Gambling class is a crime against public morals. And you are aware that gambling is governed by a special law. And I understand somebody will be discussing penal laws which are among the penal laws included in your bar examination. Okay? Gambling, and then you have this 201 regarding grave scandal. Grave scandal. Of course, grave scandal is simply a crime which is not defined in any other provisions of the revised penal code. If there is another crime, do not apply grave scandal. For instance, the accused is committing an act of lasciviousness inside a movie house. All right. That is plain and simple acts of lasciviousness or unjust vexation, although it is scandalous and not a violation of Article 200. And of course, since it involves public morals, it must be committed in the eyes of the public, in the eyes of the people. Okay? In the eyes of the people. So that if it is inside the house, although some people may see the house or peep inside the house, or worse, with the use of a binocular, they can see some scandalous acts committed therein, that is not a crime. But in one case, class, the Supreme Court said, even if committed within the compound of a private place, if it is open to the eyes of the public, then it can be a violation of Article 200. How is that possible? Of course, if the house is located on the ground, and there are several houses surrounding that place with 2 stories or 3 stories, and they can see that very scandalous act being committed therein, then still there is a crime under Article 200. I have given an example regarding 201, regarding this publication, indecent publication. Again, it involves a publication where the public can secure a copy of this indecent publication. And finally, prostitution. Prostitution. Prostitution involving minors are not or is no longer a crime. They are not criminal offenders anymore, neither are they children in conflict with the law. This particular provision was already decriminalized by 9344 in relation to Republic Act 7610, child abuse. In fact, class, it is provided expressly in 7610 that the users are the one who are liable when they engage the services of minors as prostitute. Supposing the prostitutes are no longer minors, are they still liable or can be held liable under Article 202 of your revised penal code? All right. As long as these prostitutes are victims of trafficking class, they are working under a person, sustaining them, and gain profit out of their services as prostitute, that is trafficking. They are likewise not liable. The users of these traffic women, yung mga nasa kasa, yung mga nasa sauna bath, these are considered traffic women. They are being abused by their employers, even if they agree that is they are a prostitute, and yet they are victims of trafficking under Republic Act 9208. They are not liable. Users are the one who are liable. Hence, the only possible offender under 202 are prostitutes who are acting by themselves, or they are acting in their own, and they are not the victims of trafficking, neither are they minors. Okay? 202. So you already know what or whom do you engage for purposes of this 202 and who are liable under 202. And then we go to Title 7. Crimes committed by public officers. Sir, is the concept of a public officer under our Constitution, under our public corporation, administrative law, the same as the concept of a public officer in criminal law? Unfortunately, it is not, because the definition of a public employee, in so far as your revised penal code is concerned, is broader. It involves any person in the government, rendering public service. It does not matter whether he is receiving a compensation or not. And this definition under 203 class should also be related to the definition of an public officer in your 3019, because in 3019, such public officer disregarded the classification under the civil service, whether classified or unclassified under your civil service rules. It does not matter. They are considered as public officers. You take note of then Laurel, you know Mr. Laurel, the vice president who almost became a president, the vice president who yielded to Cory Aquino to become president. Yes, you know him, Laurel. Laurel class accepted a position, an honorary or position under the NCC, National Centennial Commission, chairmanship to implement the policies of the National Centennial Commission. All right. And you are aware that he was charged for violation of the Anti-Graft and Corrupt Practices Act. And he was tried before the Sandigan Bayan. He questioned the jurisdiction of the Sandigan Bayan on the ground that he is not a public officer. He is not a public officer according to him because he is not working with the government. He is merely acting as the chairman of the NCC. Secondly, he does not even receive a salary. It was a sort of a something like pro bono, of course pro bono for a lawyer, gratis et amore. He did not receive. It is just a plain and simple public service, free of charge. And for doing such, according to him, he should not be prosecuted as a public officer, maybe as a private individual. The Supreme Court did not sustain Mr. Laurel. The Supreme Court said, in criminal law and in the determination whether one is a public officer, it is enough that one is performing a public function. As chairman of the NCC, he was performing a public function because he is executing the policy of the government. The policy of the government. Hence, he can be charged under the Anti-Graft and Corrupt Practices Act. Before he could be tried, unfortunately, Mr. Laurel died. Yes, he died pending that charges. And of course, under Article 89, what will happen if an accused dies? His liability is extinguished, including the civil liability, following the case of People versus Bayotas. Bayotas class was not yet jurisprudence when we took the bar exam. So our answer was different. Our answer was different. There was a survivorship of the civil liability, meaning the civil liability survived. But at present now, with the promulgation of the People versus Bayotas case and subsequent cases, the criminal liability is extinguished upon the death of the accused. Okay. So there is no distinction whether it is a public officer or a public employee. In fact, class, the Supreme Court even went further that it is not the designation. It is not the designation, but the duty performed by this person which determine whether he could be considered a public officer or not. In one case, class, a mere laborer, a mere janitor were considered as a public officer because they were likewise doing public service. They were likewise doing public service. Let us take up some of the crimes punishable under Title 7. By this time, class, you know already what are the common crimes defined and penalized under Title 7. Tama? Yes, sir. We know them already. Abuses against chastity, malversation, bribery, maltreatment. Is there a crime when an elective public official, he got elected but refuses to discharge his function, refuses to perform his function? Is there such crime? Sir, that is obscure, especially in the Philippines, where Filipinos would spend millions of pesos only to get elected. And it is quite impossible that after getting elected, they will refuse to take their position and exercise their functions. Sir, that is not the kind of culture of Filipinos. Of course, it is still a crime because you are violating the will of the people in electing you. That is found in Article 234. 234. A refusal to perform an elective public office. As I have said, this one is obscure. Obscure, and I have yet to find someone who will be convicted for that matter. Convicted for that matter. All right? 204. All right. Rendering an unjust judgment. Who are liable? Trial courts, justices, justices of the Court of Appeals, justices of the Supreme Court, commissioner of the SEC. Are they liable for rendering an unjust judgment? How about these prosecutors who conduct a preliminary investigation? Class, these prosecutors, these commissioners in the Securities and Exchange Commission are not liable. Only judges are liable under 204 for the rendition of an unjust judgment. In one case, class, the judge acquitted an accused in a bigamy case, on grounds of mistake of fact. In this case, class, it involves the accused secured a divorce from a foreign country. He went back to the Philippines, and after a while, he courted a woman and got married the second time around. Charged for bigamy, he invoked mistake of fact, arguing that I honestly believe that my marriage, but my divorce secured abroad already obliterated my first marriage, and therefore I could marry again the second time around. This judge sustained the argument, the defense of the accused, and acquitted him. So, subsequently, the judge was sued for rendering an unjust judgment under Article 204. Why unjust judgment? Because the judgment is wrong. It is unjust. Why wrong? Why wrong? Because the argument, the defense, is not a mistake of fact. That is a clear case of a mistake in the interpretation of a law. Mistake of law is not the same as a mistake of fact. While a mistake of fact exonerates an accused, a mistake of law does not exonerate an accused, following your principle of ignorantia his neminem excusat. But then, class, the judge was not convicted of rendering an unjust judgment. Why? The Supreme Court said, while there may be a judgment that was unjust, yet this is a felony committed, and just like any other felony, the necessity or the element of malice is also required. Since there was no malice or intention on the part of the accused, then the accused cannot be held liable under 204. At most, said the Supreme Court, he can only be held liable administratively. Thus, he was suspended and at the same time fined for ignorance of law. Ignorance of law. But not for violation of 204. Note, class, that this this article is applicable only to single judge, not to a collegiate courts, not to a collegiate courts. And be very careful, class, when you become a lawyer. Do not sue the justices, the Supreme Court, for rendering an unjust judgment. Why? If you will do that, class, you will be disbarred. In re Laureta. Yes, because Mr. Laureta, Attorney Laureta, charged the justices for rendering an unjust judgment. Okay, disbarment. But the question is, who will determine whether or not there is an unjust judgment? Who will determine? Of course, there must be first be a determination whether the judgment is wrong or unjust by the appellate court or by the court administrator before a charge of 204 could be initiated or instituted. Okay? Dereliction of duty under 208. May a policeman be held liable? If a policeman saw an altercation and the suspect hit the victim and then allowed the accused suspect to leave the premises. If a crime of robbery was committed and the policeman refused to apprehend, can he be liable for violation of Article 208, dereliction of duty? The answer is no. Why not? Why not? The policeman is not engaged in the prosecution of offenses. Article 208 class is applicable only to those public officers who are who have the function or duty to prosecute. The policeman who allowed the commission of a crime may only be held liable as an accessory for the crime. Accessory for the crime. Dereliction of duty. That is under 208. And then you now come to Article 210. This one is a very common question in the bar exam. What is 210? 210 is direct bribery. Okay? 210 class is a very good example of malfeasance, misfeasance, and non-feasance. 210 has 3 paragraphs. The first paragraph actually is a malfeasance because the accused, who is a public officer, committed a violation of law in the performance of his duty. He did his function wrongfully. Unlike the second paragraph, it is misfeasance. What is misfeasance? All right. He did a misappropriate, or he did not perform his duty appropriately. Kaya nga, misfeasance. Alright? Misfeasance. There was an inappropriate performance of his duty. And lastly, class, the third one is non-feasance. The accused here failed to perform his duty or did not perform his duty which he ought to perform. Remember, class, that malfeasance should not constitute a crime. So that if there is a dereliction of duty, non-prosecution of a certain offense, that is not malfeasance, but it is still considered as a malfeasance. Why did I distinguish this? For purposes of violation of 210 class, there is a difference in the modality of violation. There is a distinction. For purposes of malfeasance class, under paragraph 1, it is enough that there is an agreement. It is enough that there is an agreement. It is not even necessary that the money, the property, or anything is delivered to the offender public officer in consideration in the performance of his duty. In consideration of the malfeasance, agreement is sufficient. For instance, the accused agreed, class, to falsify the register of deeds, agreed to falsify a certain the certificate of title. Normally, class, in bribery, there is an entrapment in order to apprehend the offenders. Because this is a crime which is committed by two individuals. The person who offer the money, to offer the consideration, is liable for corruption of a public officer. And the receiver, the offeree, the public officer is now liable for bribery. All right. So that if falsification is actually committed, then two crimes are committed. Two crimes are committed. And both of them are liable for the second crime committed. So, the offeror will be liable for corruption of a public officer, and the offeree, the public officer, will be liable for bribery. And for the crime of falsification, the public officer will be liable as a principal by direct participation, and the offeror is liable as a principal by inducement. Okay? Principal by inducement. On the other hand, malfeasance, you provide a favor which is not ordinarily given to ordinary individuals. You favored one, or in the application, for instance, for driver's license or any other application for a government transaction, you gave him a advantage which is wrong. All right. For this reason, class, there must be a gift received. In other words, the consideration must be received as to whether or not the act performed will increase the penalty. Increase the penalty. In the same manner, class, in malfeasance, the consideration must also be received. The consideration must also be received. All right. How would you distinguish? How would you distinguish indirect bribery from direct bribery? How would you distinguish? Supposing you give Pedro 100, the civil registrar 100 pesos. Bilisan mo naman ang pagpe-prepare ng aking certificate of title, unahin mo na ito dahil kailangan ko at binibili na ng buyer, and there is a deadline, okay? And that money was received by the public officer. Would this constitute direct or indirect bribery? All right. Be very careful, class. Be very careful. Bribery. When you say, by reason of his office, by reason of his office, that is a case of indirect bribery. You simply deliver a consideration. You deliver your money because of the office, because of the position, without any other consideration. But when you say, in consideration of the office, class, just like any other, just like an ordinary contract, when you give a consideration, there is an obligation which must be performed. In other words, if that is the case where there is a consideration, then it becomes a direct bribery. Direct bribery. In consideration of the performance of his function. To be more exact, you will say, in direct bribery, there is a delivery of money or a consideration. There is a delivery of consideration for the performance of his function. Whereas in indirect bribery, plain and simple, because of his office. I repeat, if you give money by reason of his office, but he has to perform a function, that is already direct bribery. Direct bribery. Okay? Direct bribery. Note the distinction between bribery and robbery. Robbery. Some of your books, of course, distinguish it in the sense that there must be a crime committed plus the fact that there is force and intimidation. The real distinctive criteria is the presence of force or intimidation. So that if the victim parted with his money because of the intimidation, which may be by reason of the performance of his function by the public officer, that is plain and simple extortion amounting to robbery. If there is no force or intimidation, there is somewhat a voluntary exchange for the in consideration of the performance of his function. There you go, class. It is bribery. Bribery. Notice that if it is bribery, it relates to a voluntary act on the part of the other person because of the necessary liability of the other person, which is corruption of a public officer. Kaya nga doon sa robbery na pinilit, even if there is a crime committed, but he was compelled, how would that other person or the suspect be liable? Corruption of a public officer. Mag-asawa ang corruption and bribery. Kaya that is the real criteria for determining whether it is bribery or robbery. Okay? Now, this crime of direct bribery and other crimes under Title 7 are sometimes the same acts made punishable by Republic Act 3019. There is in 3019 the act of asking, requesting for a gift or present in consideration for the performance of certain act. All of these, causing undue injury, malversation, class, are also defined in 3019. Under the present set of jurisprudence, there is no prohibition that a person will be held liable under 3019 and at the same time under the revised penal code. No double jeopardy, even if it arose from a single act of the accused. 2 convictions can be sustained. One under the revised penal code and the other one under 3019, which is considered as a special law, Let's move on. 210, we move on to 213, illegal exaction. Take note, illegal exaction in relation to malversation. Is there a relationship of illegal exaction and malversation? Yes. The offender both in 213 and 217, malversation, are accountable public officers. Accountable public officers. The only difference, class, is that in illegal exaction, the accountable officer class has the function to collect fees. Collect fees. So, if he is not an accountable public officer and at the same time the duty to collect fees, no illegal exaction is committed under 213. All right. The mere act of demanding, the mere act of failure to issue a receipt, the mere act of asking for a different payment is illegal exaction. So even if the accused who asked for a higher amount was not acceded to, or the taxpayer did not comply to pay a higher amount, there is already a crime. Of course, take note, class, that more often than not, a higher amount is being asked for the public officer to abstract or spend or appropriate that excess amount. So, if the offender, accountable public officer, demanded 1,000 instead of 800 only. 800 only. Okay? And the taxpayer paid 1,000. And he gave a receipt of 800 only, because that is the amount payable. And then there is an larger amount, which is 200 excess, which was not receipted. Okay? Which was not receipted. And in the duplicate copy, 800 was actually put in. Ask why 1,000? And the public officer said, there is a miscellaneous payment which need not be receipted anymore. Ginagawa yan eh. Sir, pang-kwan ho yan. Yung pang-docu, ano yung docu? Documentary, stamp tax. Alright, so no receipt is given. Alright. If no receipt is given, class, there is a crime of illegal exaction, and the additional amount, the excess amount, becomes a private amount or private property, which is in the possession of the public officer. And it will not be malversation, but it would become a case of estafa. And it would seem that since illegal exaction is a necessary means to commit estafa, it becomes a complex crime. Complex crime of illegal exaction, estafa through illegal exaction. But supposing, let us change the facts. 1,000 was asked instead of 800. Okay? Binayaran, 1,000. Humingi ng resibo, 1,000 ang binigay. Okay, no problem. 1,000 receipt, 1,000 was paid. But since 800 is only the legitimate amount, anong ginawa ng public officer? Doon sa duplicate, triplicate copy, inilagay 800 only. And then, the excess of 200 pocketed, misappropriated. Would your answer be the same? Of course, this time, no. Why? Because the 200 excess demanded under illegal exaction becomes a public fund or property. Hence, if misappropriated, then it becomes a crime of malversation and no longer estafa. Hence, if it was indeed the intention of the accused to get an extra collection and issued a receipt, official receipt, then the whole amount of 1,000 becomes public money. The extraction, appropriation of 200 becomes a crime of malversation. How about the receipts? 1,000 original receipt, triplicate, duplicate, 800 only. Would it also be complex? No more. It cannot be complex. Why? Because this is intended to conceal the crime. And you are aware that if a crime is intended to conceal another crime, there is no complex crime. There could only be complex crime is if the other crime is necessary to commit the other offense. Hence, it would be a separate crime of falsification of a public document. So, in this case, there would be malversation through illegal exaction plus the crime of falsification of a public document. And then we go to malversation. Under malversation class, take note the definition of an accountable public officer. If the accused is not an accountable public officer, then he could not be held liable for malversation. Take note that an accountable public officer is one who has also control and supervision. It is not enough that he is in possession of the money. He must have control and supervision. He has the function to safekeep the money. Safekeep the money. Okay? Otherwise, if it's only a physical, temporary in character, then he is a mere possessor of that money. He is not liable for malversation, but for qualified theft. Qualified theft. A cashier class. A cashier is considered as an accountable public officer because he has full control of the money. He has full control of the money while it is in his possession, you see? While it is in his possession. All right. Accountable public officer. Secondly, public fund or property. Do not limit yourselves in defining public property or fund as those property or fund belonging or owned by the government. Because even if a money or fund is owned by a private individual, it can still be the subject of malversation. If that property is governed under Article 222, yan pa ba ang loading ng globe? 222? If you load with your globe, 222? Kasi I am not a globe user. Never mind, whatever is my cell phone provider, okay? Cell provider. So under 222, even if a property is owned privately, if it is deposited to an accountable public officer, or if it is attached, or if it is seized by a public officer, then it becomes the nature, or it also partakes the nature of a public fund or property. Kaya yung policeman, as I have said, who apprehended a thief and appropriated the subject matter of the crime is liable for malversation. Malversation. So that if that policeman sold this property subject of the crime which he took from the thief, what will be the liability of the buyer, knowing that this is the subject of malversation? Fence? No, sir. Why? Because fencing is applicable only to, very good, robbery or theft, not for any other crime. Not for any other crime. Of course, he may be an accessory for having profited from the effects of the crime. So careful. Those simple things. I am really worried next year, not so much with you, because next year, matching type or multiple choice. And for that reason, you have to get the exact answer, black and white. Unlike an essay, pwede pang mag-argue correctly when you have your good English and grammar. So, class, I wish all of you will pass the bar exam so that you will not find this difficulty next year. You will not find this kind of difficulty next year. See to it that you will now make it this time, by hook or by crook. All right. So that is the concept of a public fund or property relate to Article 222. Likewise, if the purpose of those public property in the accountability of a public officer or even a private individual or even a private may also be liable for malversation. How is this purpose and accountable public official? Money given to Mr. Binay as a private individual in his capacity as an officer of the Boy Scout. Mukhang Boy Scout kasi si Mr. Binay, Vice President Binay, especially when he is in his short pants. So, this money which are contributed to your Boy Scouts are also public fund or property because they are intended for a public purpose. The same with those given to Mr. Sino ba yung tumakbong presidente na senador? Gordon, yes, because he is also an officer of this National Red Cross. Plus, these accountable officers involving funds of the National Red Cross may be held liable for malversation because the money in their possession partakes the nature of a public fund of property because they are intended for a public purpose. Public purpose. Okay? Public purpose. Note that malversation does not require direct proof. Circumstantial evidence is enough. So, after a determination that there is a shortage and there is a demand and there is no fund forthcoming from the accountable public officer, then there is a presumption that this fund or property was put into, was misappropriated. But take note, class, that this demand, before it could give rise to a presumption, must be complete, regular, and regular, pursuant to the your manual of audit. So that if it is not complete and regular, as the auditor failed to include some other accounts which is supposedly to be included, this presumption will not arise. This presumption will not arise. And even if this presumption will arise, it is still rebuttable presumption. You know what is the meaning of a rebuttable presumption. Okay. Note, class, that this is the only crime that can be committed by means of dolo and culpa with the same penalty. Dolo or culpa with the same penalty. Okay? And take note also the distinction between malversation and estafa, malversation and technical malversation. By the way, what is technical malversation? Technical malversation, class, is the misappropriation of a public fund for a public purpose. Okay. Yung funding, ginamit, yun yung usually what you call this as juggling of funds. This is a crime. If there is already an appropriation, and an appropriation is considered an ordinance or a law, and this appropriation was not used, the money appropriated for that particular purpose was not used for that purpose intended, then it becomes a crime of illegal use of public fund under Article 220 or the so-called technical malversation. Take note that a charge for malversation does not include or necessarily include technical malversation. So that if the crime charge is technical malversation and what was proven was malversation or vice versa, there could be no conviction. What will happen to the accused? If charged for malversation, naging technical malversation pala, ano mangyayari? What will happen? Acquittal? Of course, no acquittal, but substitution of the information. And meantime that there is a substitution of the information, class, the bail shall remain, including the witnesses may even be required to post the bail. And there will be another preliminary investigation for that purpose. Well, this is already beyond my subject, and I might be charged with usurpation of public function because a professor is also a person in authority. But of course, we are not performing a public function, and we cannot be charged under 177. 177 is usurpation of public function. While we are public person in authority class, the professor is limited only to Articles 148 and 151. There being a person in authority is limited to 148 and 151. All right? I think we need, not only me, we need a break. Let us take a break.